For most of American history, the law had a blunt answer to a hard question. If your employer promised you a pension and later refused to pay it, could you force them to keep that promise? In courtroom after courtroom, American judges said no. A pension was a gift. And a gift, the reasoning went, belongs to the giver right up until the moment it lands in another person's hand. However, for a brief window that opened in the 1970s, that answer changed. And the same decade had already begun building the door that would change it back. To understand how strange that window was, you have to start with the doctrine that governed the century before it. The story usually told about American pensions opens with a factory closing in Indiana. The real beginning is quieter, and it sits in a New York courtroom in 1898. A worker named McNevin had put in his years at the Solvay Process Company, a chemical maker in the town of Solvay near Syracuse. The company operated a pension plan. When McNevin's share came due, he figured it at roughly $50 and the company would not pay him, so he sued, $50 in a New York court against a chemical company, and he lost. The reason he lost mattered far more than the money did. The court ruled that a pension, before it is ever paid out, is what the judges called an inchoate gift, an unfinished gift, a promise of generosity that the giver may withdraw at any moment, for any reason, or for no reason at all. Until the check is in the worker's hand, the worker owns nothing. He holds an expectation, and an expectation is not a debt. That case, McNevin against Solvay Process, was affirmed by New York's highest court in 1901, and it became the cornerstone of what the lawyers came to call the gratuity theory of pensions. Even that opinion left one narrow crack open, hinting that outright bad faith in the running of a plan might be challenged in a court of equity. But the crack was so small that almost no worker ever managed to fit through it. Under the gratuity theory, a pension plan created no enforceable right whatsoever. An employer could shrink it, modify it, or cancel it outright, and the courts would read every ambiguity in the employer's favor. For the next 50 years, that was the settled law of the land. A man could give a company 40 years of his life and walk away with nothing, and no judge would call it a broken contract, because in the eyes of the law, there had never been a contract at all. There had only ever been a gift, and the company was free to take it back. It helps to see where these plans came from, because it explains why the law handled them so gently. The first formal corporate pension in the United States is generally traced to the American Express Company in 1875. This was the old American Express, a freight and express delivery business, long before the credit card ever existed. Its plan covered workers who had reached the age of 60, who had given the company 20 years of service, and who had been judged too infirm to keep working. If you qualified, a manager still had to recommend you, and the board of directors still had to approve you, and only then might you receive half your salary in retirement, capped at $500 a year. Every step in that process sat inside the company's hands. That design was no accident, and it was hardly charity in any sense we would recognize. A pension in that era was a tool of management. Railroads and banks built the early plans, and they built them to reward loyalty and to punish the workers who left, or who organized, or who lingered too long talking with the union man at the gate. Leave your job, and you forfeited everything. A pension also solved a delicate problem for the employer, which was how to move aging workers off the floor without appearing cruel. It let a company retire a 60-year-old with a measure of dignity while keeping the discretion to deny the very next one. The gift only worked as a tool because the giver could always take it back, and the law, by naming it a gift, agreed. The system spread once the tax code started rewarding it. A Revenue Act in 1921 let employers deduct their pension contributions, and companies like Eastman Kodak, Goodyear, and Standard Oil moved in. By the mid-1920s, a couple hundred plans existed across the largest firms, though even then the rules were stern. An early Baltimore and Ohio Railroad plan, for instance, paid a decent share of your wage, but only if you reached 65 and only after long service, and a stumble along the way could erase the whole thing. By 1950, only about a quarter of the private sector workforce was covered by any plan at all, nearly all of it still resting on nothing sturdier than the employer's goodwill. Even the judges grew uneasy with what they were being asked to enforce. In a New York case in 1941, a court admitted that treating these plans as purely voluntary did not match the reality of working life, and that in some instances the result was so contrary to the facts that it could shock the conscience of the very court forced to hand it down. Yet the doctrine held anyway. As late as 1957, a New York court reaffirmed that a pension remained a gratuity, revocable, unenforceable, the companies to give and the companies to withdraw. Half a century after McNevin sued for $50, the law had not moved an inch. The first real crack in the gratuity wall did not come from a judge at all. It came from the bargaining table, and it came through a side door in labor law. In 1948, the National Labor Relations Board took up a dispute involving the Inland Steel Company, and it ruled that a company's pension plan was not a mere gift, but a form of wages, a condition of employment that the employer was legally bound to bargain over. A federal appeals court affirmed that ruling later the same year, and when the Supreme Court declined to disturb it in 1949, the principle stood for every employer in interstate commerce. Pensions were wages. That single reclassification quietly turned a gratuity into something a union could demand. The industrial unions seized the opening immediately. Above all, the United Auto Workers forced pensions into their contracts with the great manufacturers, and by the end of the 1940s they had negotiated plans at General Motors, at Ford, and at Chrysler. Those plans were different in a way that changed everything. They were bargained. They were written into a labor contract, exchanged for wage restraint and labor peace, and that finally made them look like a promise the company truly owed rather than a favor it might revoke. But turning the gift into a contract solved only half the problem, and it planted a new one that would take 25 years to detonate. A company could now be bound to pay a pension. Nothing in the law required it to set the money aside in advance. There was no funding standard at all. A firm could promise a rich benefit, put a fraction of the needed money into the pension trust, and carry the rest as little more than a hope. On paper, especially the loose paper of pre-reform accounting, the shortfall barely showed. The true funded condition of a plan was invisible, not only to the workers counting on it, but often to the public and the press as well. A pension could look perfectly healthy right up until the day the company standing behind it stopped being healthy. The promise was solid. The money behind the promise might be a rumor. Which brings us, at last, to the factory in Indiana. Studebaker had been building vehicles in South Bend since the age of the covered wagon, hauling supplies for the Union Army before it ever built a car. By the early 1960s it was dying, not because it made bad automobiles, but because its finances had been mismanaged for years. On the 20th of December 1963, the South Bend plant shut down production. Soon after, the company terminated the pension plan covering its hourly workers, and that plan came up desperately short. The gap between what it owed and what it truly held ran to about $15 million, and because the plan was broke, the only way to guarantee anyone's benefit was to spend the remaining money buying annuities. At the time it collapsed, the plan covered somewhere around 10,500 workers in all. This is the place where nearly every retelling goes wrong, and the truth turns out to be harder and more disturbing than the myth. The popular version says Studebaker changed the rules and cheated its workers. It did no such thing. Under the contract the auto workers themselves had negotiated, when a plan terminated, the available money was to be paid out in a strict order of priority. It went first to those already retired, and next to those closest to retirement. And that is precisely what happened. Roughly 3,600 workers who had already retired received their full benefits, every dollar they had been promised, exactly as the contract required. The workers standing just behind them in line were destroyed by that same clause. About 4,000 employees between the ages of 40 and 59, with an average age of 52 and an average of 23 years on the job, received around 15 cents for every dollar of the benefit they had earned. And the workers with the least seniority, some 2,900 of them, received nothing at all. Their share had already gone, entirely lawfully, to the people ahead of them. So two things were true at the very same moment. Studebaker honored the contract, and its workers were wiped out all the same. The scandal was never a broken promise. The scandal was that keeping the promise, exactly as the law had allowed it to be written, still left thousands of middle-aged men with almost nothing to show for a lifetime of work. And because there had been no requirement to disclose the plan's true condition, none of them had seen it coming. The auto workers had, in fact, watched a version of this before, and that earlier warning is the piece the popular story leaves out. Studebaker had merged years earlier with Packard, and back in 1958 the company had terminated the old Packard plan. The Packard workers got even less than the Studebaker workers eventually would. That failure convinced the president of the United Auto Workers, Walter Reuther, that his union faced a danger it could not bargain away on its own, the danger that a plan would run dry the day a company died. He called it default risk. And beginning around 1962, the union started promoting a remedy that had never existed in American law, a form of insurance for the pensions themselves, which they called pension reinsurance. That idea became legislation faster than anyone expected because Studebaker had handed the cause a perfect symbol. Working alongside the Union, Senator Vance Hartke of Indiana introduced a bill in August of 1964 called the Federal Reinsurance of Private Pensions Act. It did not pass, but it placed the idea of federal pension insurance onto the national agenda for the first time in the country's history, and it fixed Studebaker permanently in the public memory as the case that proved the system was broken. A Senate staffer would later describe the Studebaker shutdown as the most glorious story of failure in the business. For all its weight, though, Studebaker alone did not force Congress to act. A decade slipped past, the bill stalled and died in committee. What finally moved the country was neither a courtroom nor a hearing room, it was a single hour of television. On the 12th of September 1972, the National Broadcasting Company aired a documentary called Pensions, The Broken Promise, reported by the veteran newsman Edwin Newman and written with the producer David Schmerler. For a full hour, Newman walked the audience through the wreckage of the private pension system. Workers were laid off just months before their benefits would have vested. Plans collapsed when companies merged or closed their doors. Funds vanished into mismanagement. One ordinary story after another of people who had done everything asked of them and reached the end only to find nothing waiting. The program struck a nerve across the country. It reached millions of viewers, and the following spring it won a George Foster Peabody Award, among the highest honors in American broadcasting. A film about broken promises had told a plain, hard truth, and the nation had stopped to listen. And that is the moment the government tried to make it disappear. The attempt arrived wrapped in the gentle language of fairness. In November of 1972, a conservative media watchdog group called Accuracy in Media filed a complaint with the Federal Communications Commission. Its executive secretary, a former professor from a defense intelligence school, argued that the documentary had shown only one side, that it had painted the entire private pension system as a fraud, without granting any airtime to the plans that worked. The complaint leaned on a rule then in force called the Fairness Doctrine, which required broadcasters to present contrasting viewpoints on controversial matters of public importance. There was a darker current running beneath that tidy complaint, and it is worth knowing where it came from. This was the Nixon era, and the administration had made a deliberate project of pressuring the networks it regarded as hostile. Inside the White House, aides had discussed working through sympathetic outside groups to file fairness complaints against unfriendly broadcasts, precisely because a private group lodging a government complaint looked like ordinary citizen concern rather than official retaliation. The routing was the whole point. It let official pressure travel through private hands and arrive wearing a clean face. The commission sided with the complaint. On the 2nd of May, 1973, as it happened the very same day NBC received its Peabody Award for the program, the agency's broadcast bureau ruled the documentary in violation of the Fairness Doctrine. Notably, the ruling did not challenge a single fact in the film. It challenged only the balance. The full commission upheld that finding and ordered NBC to broadcast the other side of the story. No documentary had ever drawn such an order from the FCC before. A network had reported that pensions were being lost across America. The reporting was accurate, it had earned the industry's highest honor, and now the federal government was ordering that network to air a rebuttal against its own true story. NBC refused to let the order stand and carried the fight to the United States Court of Appeals in Washington. The case became National Broadcasting Company against the Federal Communications Commission, and the network spent something on the order of $100,000 over 4 years defending a program it had already aired. In a decision that split the panel, the court reversed the commission's order by a vote of 2-1. A documentary about promises broken had come within a single judge's vote of being broken itself, by the state, for the offense of being true. If you find yourself drawn to history told this way, with the legal machinery left in and the easy villain taken out, consider subscribing. This channel builds these institutional origin stories one law and one hard decision at a time. By the time that fight wound down, the ground had shifted beneath everyone's feet. The documentary, the Studebaker symbol, roughly 8 years of hearings, and a mounting pile of evidence had all done their work, and Congress was ready to write a real law. It moved through the House and the Senate by enormous margins, better than 400-2 in the House on the final version. And on Labor Day, the 2nd of September 1974, President Gerald Ford signed the Employee Retirement Income Security Act. Almost everyone knows it by its initials, ERISA. Signing it, Ford told the country that working men and women would now have far more clearly defined rights to their pension funds and far greater assurance that the retirement dollars would be there when the time came. By the moment he put his signature to it, private pension coverage had grown from around 21 million workers in 1960 to nearly 31 million, and the money sitting inside those plans had swelled into one of the largest pools of capital anywhere in the economy. Some 27 million of those workers were counting on the traditional defined benefit plans the new law was built to protect. Two senators, above all others, had carried the thing that far. Jacob Javits of New York had introduced the first broad pension reform bill all the way back in 1967, and Harrison Williams of New Jersey chaired the labor committee that shaped the final result. Their fight was not the tidy story of reformers against greedy corporations. Opposition came from two directions at once. Business groups resisted the cost and the new federal oversight, which was no surprise, but a number of unions resisted too because they had spent decades constructing their own pension arrangements and did not want Washington rewriting the flexibility they had won at the table. At one point, Javits went over the heads of the assembled lobbyists entirely and took the argument directly to the voters, insisting that ordinary workers had a stake in this that none of the insiders shared. What they built was something new in American life. For the first time, federal law imposed a minimum funding standard, so a company could no longer promise a pension and leave the trust behind it half empty. Vesting rules meant a worker who put in enough years earned a right to benefits that a convenient layoff could no longer strip away. Disclosure requirements meant the funded state of a plan could finally be seen in daylight. Fiduciary duties bound the people managing the money to manage it for the workers rather than for the company. And a new institution was created to catch the plans that failed anyway. That institution was the new Pension Benefit Guaranty Corporation. Modeled on the way the Federal Deposit Insurance Corporation stands behind the money in your bank, it was funded by premiums paid in by the pension plans themselves, and it would ensure the benefits of a terminated defined benefit plan up to a limit set by law. The gift had become a right, backed at last by the machinery of the federal government. The same law along the way created the individual retirement account. An honest account has to record the compromises baked into that victory, because the business lobby did not walk away empty-handed. The funding standards let companies stretch their deficits out over very long stretches of time, which meant a plan could sit legally underfunded for years on end. The vesting rules, real as they were, still permitted long waiting periods before a worker's benefit locked in for good, and the Guarantee Corporation was left structurally exposed, insuring enormous plans while collecting fairly modest premiums, so that a single wave of giant terminations could one day threaten the insurer itself. The law was a real shield. It was also a negotiated one, carrying gaps its own authors could see and chose to accept in order to pass anything at all. Now comes the part that almost no one saw arriving, and it was written into that same decade, still busy celebrating ERISA as a triumph. 4 years after the Great Pension Law, Congress passed the Revenue Act of 1978. Buried deep inside it was a modest provision about deferred compensation, a narrow way for an employee to set aside part of a bonus before taxes. The provision carried the code number that would soon become famous, 401k. Its actual purpose was almost the opposite of what it became. Lawmakers were mainly trying to rein in the cash-deferral perks that executives had been claiming. Nobody in that debate imagined it as a replacement for the pension. It read like a small tax adjustment and nothing more. Then a benefits consultant in Pennsylvania named Ted Benna read the clause more carefully than anyone else had. Working for a firm called the Johnson Companies in 1980, Benna noticed something the tax experts had all glided past. Everyone had assumed contributions to these plans could only be made after income tax was withheld. But the language did not say that. It did not forbid an ordinary worker from deferring part of a regular paycheck before taxes and pairing it with a matching contribution from the employer. Benna built the first such plan for his own company. The government issued clarifying rules the following year, and a machine that had been meant to restrain executives became a savings account for everyone. What it created was a legal off-ramp from the entire defined benefit model. Benna himself intended it only as a supplement to the traditional pension. Decades later, watching what it had grown into, he called his own creation a monster. Consider what the two systems ask of you. A traditional pension is a promise from your employer to pay you a defined benefit for the rest of your life, and it is the employer who carries the risk of funding it, and the risk that you live a good long time. The newer account flips all of that onto the worker. You decide how much to contribute. The choice of how to invest it is yours. You carry the risk that the market falls in a bad year, and you carry the risk of outliving your own savings. The employer's obligation ends the instant the paycheck is deferred. A pension also pooled the risk of long life across thousands of workers at once, so that those who died early helped carry those who lived long. The individual account pools nothing at all. Each person's retirement now rises or falls on that one person's balance and on the sheer luck of what the market is doing in the years they happen to stop working. The account inherited the friendly, familiar name of a retirement plan, but underneath it was a fundamentally different machine, and every risk the old pension had placed on the company it placed instead squarely on you. The numbers tell the rest of it. Private pension coverage in America had peaked around 1970, when roughly 45% of private sector workers were covered by some kind of plan. For a while after ERISA, the traditional pension even appeared to flourish, and the sheer number of defined benefit plans kept climbing into the middle of the 1980s. Then the count began to fall, and it kept on falling, as employer after employer froze the old pensions and steered new hires into individual accounts instead. The law that had been written to guarantee the defined benefit pension ended up presiding over its near disappearance. ERISA made the pension safe at almost the exact moment American employers were deciding they would rather not offer one at all. So this channel closes the way it always does, on an honest ledger, and there is real weight on both sides of it. Set down first what the law truly bought. Because of ERISA, a total wipeout on the scale of Studebaker, where thousands of loyal workers lose nearly everything overnight, is far rarer today than it once was. The Pension Benefit Guaranty Corporation has paid out billions of dollars to retirees whose plans failed underneath them, and it now stands behind the pensions of roughly 30 million American workers and retirees. For the people inside a covered plan, that protection is no abstraction. It is the difference between a secure old age and the fate that met the younger men of South Bend. Now set down what the law never did. ERISA protected the pension plans that already existed. It never once required an employer to offer a pension in the first place. It guarded the promise without ever compelling a single company to make one. And into precisely that gap stepped the individual account, which took up the reassuring label of a retirement plan while leaving the guarantee behind. The federal insurance, the funding standard, the benefit promised for life, all of it stayed attached to a shrinking pool of old pensions. The system that most workers were funneled into over the following decades carried almost none of it, which returns us, in the end, to the worker at the center of the whole story. The one setting a contribution rate on a screen tonight, choosing among a handful of funds, hoping the arithmetic holds up across 30 years. That worker is the direct descendant of the man who sued the Solvay Process Company for $50 and lost. Both of them are carrying the risk on their own shoulders. Both are, when you strip it all the way down, only hoping for a gift. There is only one difference between them, and it is the whole difference. The law once forced that risk onto the worker through silence because no one had yet thought to protect him. It forces the same risk onto him now on purpose. The guarantee did not slip away by accident. It was handed back by design. That is where the ledger stands. If you want the next chapter, the story of how that small individual account grew into the very center of American retirement, follow along and we will take it apart the same careful way, one decision at a time.